Begin tonight with Iranian authorities closing their airspace for several hours this evening and the world waiting for what, if anything, might come next. The airspace reopened just before airtime, but take a look. This is what the skies over Iran looked like also as of a few moments ago. Additionally, some personnel at the U.S. airbase in Qatar have been urged to leave, according to a U.S. official who spoke to CNN earlier. Also tonight, a warning from Iran and a chilling assessment from its hardline regime. Well, the foreign minister is talking about the strikes on his country's nuclear sites, which Iran claims did not significantly set back their effort. The President Trump says otherwise, obviously. And here's what the foreign minister said about his government's bloody repression.
The silence in that courtroom wasn't symbolic. It was structural. It was the sound of the American legal system finally refusing to blink. A judge looked directly at Donald Trump and said in plain language that the rules apply to him, not hypothetically, not eventually, now. Immediately, delete the posts, pay the fine, stop, or the next step is a jail cell. That moment matters more than the dollar amount. It matters more than the headlines. It matters more than the predictable outrage machine that spun up within minutes. Because what happened there was not a media moment. It was a stress test. And for the first time in years, the judiciary did not yield. Strip away the noise, and here is what actually occurred. Donald Trump, the defendant in a criminal trial, violated a court-ordered gag order repeatedly. Not accidentally, not ambiguously, openly, publicly, after warnings, after explanations, after patience. He attacked witnesses. He targeted jurors. He undermined the integrity of the process in real time, knowing exactly what he was doing and daring the court to respond. And the court finally did. Criminal contempt is not a rhetorical rebuke. It is not a strongly worded opinion. It is the judiciary reaching for one of the few enforcement tools it has left when a defendant decides that court orders are optional. The fine was immediate. The compliance deadline was same day, and the escalation path was stated out loud on the record with no wiggle room. Continued defiance would lead to incarceration. That sentence alone detonated decades of unspoken assumptions. Because American courts are built on compliance, not force. Judges do not have armies. They do not have police departments loyal to them personally. Their authority exists because people believe that defying a court is worse than obeying one. Trump has spent years testing that assumption, turning compliance itself into a political statement and daring institutions to prove they can still function. This was the first time a judge answered that dare without flinching. You could feel the shift. The judge was no longer negotiating with a political phenomenon. He was addressing a defendant. And the defendant was being treated as a defendant because anything less would have rendered the court irrelevant. This is where pattern recognition matters. Trump's behavior in this case is not unique. It is archetypal. It is the same playbook he has used against inspectors general, prosecutors, journalists, civil servants, election officials, and even his own appointees. Identify a constraint, violate it publicly, frame enforcement as persecution, mobilize outrage, dare the institution to either escalate or retreat. Most institutions retreat. Courts have tried for years to thread an impossible needle with Trump. Enforce the law without triggering a constitutional crisis. Protect witnesses without inflaming his base. Preserve due process without turning the defendant into a martyr. The result has often been paralysis disguised as restraint. Warnings without teeth. Orders without consequences, a slow erosion of authority justified as prudence. What happened in that courtroom was the rejection of that strategy. The gag order itself is not radical. It is not novel. It is not unconstitutional. Gag orders exist precisely because trials are fragile ecosystems. Witnesses are human beings. Jurors are citizens. When a defendant with a massive platform targets them, the damage is immediate and often irreversible. Courts have long held that limited, narrowly tailored restrictions on speech are permissible when they protect the integrity of judicial proceedings. This is black-letter law. Trump knows this. His lawyers know this. The argument that the gag order violates the First Amendment is not a serious legal position. It is a political one. It is designed for television, not appellate courts. It reframes accountability as censorship and obedience as surrender. And that framing is the real danger. Because this is not just about whether Trump deletes a post. It is about whether court orders mean anything when the defendant is powerful enough to ignore them. If a judge issues an order and the defendant violates it without consequence, the order ceases to exist in any meaningful sense. Authority collapses not in dramatic coups, but in quiet acquiescence. The judge understood that. That is why the response was immediate. no delays, no extended briefing schedules, no opportunity to turn compliance into a months-long spectacle. The message was simple. The court will not be managed by the defendant. This is where the constitutional implications become unavoidable. Trump is not just a criminal defendant. He is a political actor with the ability to mobilize millions. He is also, at various points in this saga, a sitting president or a leading candidate for the presidency. That dual status creates a collision between branches of government that the Constitution did not explicitly blueprint, because it assumed a baseline of good faith that no longer exists. The judiciary has no explicit enforcement mechanism against a president who refuses to comply. There is no clause that spells out how to jail a head of the executive branch. The system relies on norms, on mutual recognition of limits, on the idea that even the most powerful officeholder accepts the authority of the courts. Trump has systematically rejected that idea. His attacks on judges are not rhetorical flourishes. They are part of a strategy to delegitimize any constraint on his power. When he loses, the system is corrupt. When he is restricted, the Constitution is violated. When he is sanctioned, he is a victim. This is not grievance. It is conditioning. It teaches supporters to view the rule of law itself as an enemy. That is why the contempt ruling reverberates beyond this case. Other judges are watching. Other prosecutors are watching. They have faced the same dilemma. How do you enforce orders against someone who weaponizes every act of enforcement as proof of persecution? How do you protect witnesses when the defendant's intimidation is amplified by a global platform? How do you preserve due process when the defendant is actively poisoning the jury pool? The answer cannot be perpetual hesitation, because hesitation has consequences. It teaches future defendants that defiance works. It teaches future presidents that judicial orders are suggestions. It teaches the public that power, not law, determines outcomes. The contempt ruling disrupts that lesson. It says escalation is not theoretical. It is procedural. It follows from behavior. If the defendant continues, the penalties increase. If the penalties fail, incarceration becomes an option, not because the judge wants to make history, but because the court cannot function if its orders are optional. This brings us to the most uncomfortable question in American governance. What happens if a president refuses to comply with a court order? The Constitution does not give a satisfying answer because it never imagined a president who would test it this way. The system assumes that the executive will enforce judicial rulings, even when they are inconvenient. It assumes that the Secret Service protects the president, not shields him from lawful orders. It assumes that legitimacy matters more than brute force. Trump has shown a willingness to shatter those assumptions. If a judge orders compliance and the president refuses, the crisis is not legal in the narrow sense. It is constitutional in the deepest sense. It forces a choice between rule of law and rule of power, between a system where offices are constrained by law and one where law bends around offices. That choice is no longer abstract. The contempt ruling is a line drawn in advance of that crisis. It is the judiciary signaling that it will not preemptively surrender, that it will not assume noncompliance and adjust downward, that it will proceed as if the law still applies because the alternative is institutional suicide. Trump's reaction underscores the stakes. He did not say he would comply and appeal. He did not say he disagreed, but would follow the order. He attacked the judge. He attacked the legitimacy of the order. He framed obedience as injustice. That response is revealing because it confirms the underlying conflict. This is not about speech. It is about submission to authority he does not recognize. That posture is incompatible with constitutional democracy. Democracy does not require that leaders like court rulings. It requires that they accept them. The moment acceptance becomes optional, elections become theater, and courts become props. What remains is power enforced by loyalty, not law. This is why the fine amount is irrelevant. $9,000 means nothing to a billionaire. But the principle it represents is existential. It is the judiciary asserting that there is a price for defiance and that the price escalates. Critically, this is not judicial activism. It is judicial survival. Courts cannot function if defendants dictate the terms of their own restraint. Gag orders exist because the system learned over centuries that intimidation destroys justice. Ignoring that lesson because the defendant is politically dangerous is not caution. It is capitulation. There is also a future-facing dimension that cannot be ignored. Every action taken in these cases teaches future presidents what they can get away with. If Trump can violate orders with impunity, others will follow. If he can attack witnesses without consequence, others will escalate. If he can delegitimize courts and still govern, the damage will outlast him. Conversely, if courts enforce their orders even under pressure, they reaffirm a boundary that future leaders will think twice before crossing. That is why this moment matters beyond Trump. It is about whether the judiciary still believes in its own authority. It is about whether the Constitution is a constraint or a suggestion. It is about whether the country is governed by laws or by the audacity of those willing to break them. None of this guarantees compliance. Trump may continue to defy. He may escalate rhetorically. He may dare the court to take the next step. And if that happens, the system will be tested again, harder. But for the first time in a long time, the test was not met with delay or deference. It was met with enforcement. History rarely announces itself cleanly. It often arrives disguised as procedure, a ruling, a deadline, a fine, a sentence spoken calmly in a room where everyone understands the implications but pretends not to. This was one of those moments. What happens next will tell us whether this was an inflection point or an exception, whether other courts follow or retreat, whether compliance becomes the norm again or defiance continues to pay. If you want to understand where this is going, you have to keep watching the enforcement, not the outrage. The real story is not what Trump says. It is what institutions do in response. Stay alert, because the warning signs don't arrive with sirens. They arrive with court orders, deadlines, and the question of whether anyone is willing to enforce them.